moving on to another topic. Last week I did delve into the whole situation with was sort of a patent controversy where a patent holder with a with protection over a certain type of applique embossed embroidery technique was threatening some other content creators with takedowns on their content who were doing techniques that appeared to be fairly similar. I don't know how similar, but I clipped that segment and it got a lot of response. If you haven't seen it, it's also on the channel and you can watch that. But I did a lot of research this week, and I was fully upfront with the fact that if I was to do anything more with this particular story, one, it's going to take a while, and two, it would be there's a slim chance that I would be able to do anything more on it. But I did learn a lot more about patents in the past week. I did talk to a couple people that were kind of involved in the whole situation, and I've been really trying to learn a little bit more about the patent situation and patents in general. And I did find a video that I think would be really helpful, and we're going to watch a little bit of it. I did recommend it in the community, on the community tab here on the channel, but I think this would be pretty interesting to go over, especially because I think some of you were frustrated with me for not making more like opinionated statements or, making statements of fact. And I just want to be completely upfront. Obviously, I'm not an attorney, and I'm just not very comfortable with making a lot of strong statements on an area of law that, one, I'm really not that familiar with, and two, I'm obviously not an expert in by any means. So again, I think we can have opinions on something, but I am not comfortable really spouting out speculation or, really going hard on something that I am just unsure about. So I know a lot of y'all were in the comments, and it would be very hard for me to cover this in an in-depth way without the actual analysis of a patent attorney. And I also want to preface this by saying, before I go any further into this particular topic, in order to protect myself, the patent holder who has been going after people seems to be rather litigious. So I just ask you nicely, please do not leave any chats or comments doxing the patent holder. Do not name them. Do not provide any identifying info that could leave me open to a risk. So I just ask kindly, I know the patent is publicly available site. It's publicly available on the USPTO website, government website, but I'm not comfortable with having any identifying info on the patent holder here. So please do not name them or provide any specific information about this individual, just because I'm really trying to be careful to not open myself up for legal threats as well. Okay, so yeah, I agree with this. Patents are a very confusing area, even attorneys I used to talk with. And I also did talk with a few different attorneys in the past week or so. And there are a lot of attorneys out there, but from what I understand, if they're not a patent attorney, their analysis wouldn't really be very helpful because it is such a specific area of law. So some of y'all were like, you need to reach out to like Legal Eagle or Emily D. Baker. And I do just want to point out a couple things. It wouldn't be helpful because neither of them are patent attorneys. And the other thing you have to realize is that fellow YouTube creators with like way bigger channels than me, I'm not going to even bother trying to reach out to them because they're just not going to get back to me, and they shouldn't, because, again, I don't take that personally at all, but me reaching out to someone with huge channels, it's just like it would be kind of a waste of time. They're not going to get back to me. I would not expect them to get back to me. They wouldn't be helpful because they're not patent attorneys, and it would be kind of it's considered sort of cringe to do that sort of thing. So I'm not going to do that. So if I do get in touch with someone, it would specifically have to be a patent attorney. I called the patent office, and there are so many hoops to go through to even get all the information, about the decisions and the patent holder claims for the patent. It's pretty complicated. It's pretty complicated. Okay, so the video I'm going to be showing you actually does have Kurt from Uncivil Law in it. I had some very, very brief contact with Kurt this week. He's a very busy person. So I don't want to get your hopes up. I really don't want to get your hopes up, but I do think he would have the type of insight I would need to break this down. But he's a busy guy. He's covering an ongoing trial. So if I am able to really connect with Kurt, it's not going to be for a while. All right, so let's go over the video. So this is a video from a few years ago that Kurt did with another content creator named Eric Hunley. Eric is not an attorney, but he does cover a lot of like news and legal stuff. So I want to bring this up here. So we'll do that. Let me bring this up. And I did reach out to Eric, and he did give me permission to react to this video, which was cool of him. He seems like a very nice person. So we're gonna be watching a little bit of this. Here, I'll try to full screen this in a little bit. And just a quick, just a quick thing. Eric was very gracious in allowing me to react to this video, but in order for me to react to it and for it to be for me to have more of a fair use case, I'm gonna have to start and stop it. So I'm not gonna be reacting to the entire thing. This video is linked below in the description box, and I would encourage you to watch it in its entirety. This video is from 2020, so it is from a few years ago. I do think all of the information is still very relevant. And just some background knowledge, so Eric is on the left and Kurt is on the right. Kurt, at the time of shooting this interview, was working for the United States Patent and Trade Office. Since then, he is no longer with the organization, with the department, because he is a full-time content creator, I believe. So at the time, he was working for the USPTO, but he is no longer with them. All right, so we're gonna watch some. I just found this really fascinating, and I learned a lot I actually did learn quite a bit by watching this interview. All right, so we're gonna react to a little bit of it, not all of it, but we'll react to some of it. So, and I am gonna be kind of start and stopping this to sort of interject with my own reaction. But I just wanted to show this to you because a lot of y'all were talking about patents and legal stuff. And I also think this really clears up a lot of maybe questions we have or misconceptions. I know a lot of people get confused about intellectual property, the differences between copyright, trademark, and patents. So I do think this is going to be super interesting, and that's why I wanted to show it to you. But thank you, Eric, for doing this interview because I thought it was super cool. And I'm really nerdy about stuff. I just thought this was really fascinating. Okay. All right, here we go.
With Kurt of Uncivil Law. How are you doing, man?
I'm doing pretty good. Having a decent day. How are you doing today?
I'm doing great. I've been wanting to do this for a while. I met you briefly on Viva Fry's channel, and your history.
I read and write a lot.
Okay.
In computer-based and
person and things like that. But I've been wanting to have you on because your history and current job, I believe, is working in patent law.
That is my day job, is in utility patents, particularly in computer-based and software related specifically to database and search applications. So,
all right, so Kurt, so you can see he worked with utility patents. So he was actually a patent examiner with the United States Patent and Trademark Office. So that is the branch of the government that grants patents, including the patent person we're talking about with the embroidery, applique pat, 3D applique embroidery patent. So I think Kurt will give us a lot of background info as to how this agency operates. So, all right, I'm excited about this. I watched this like more than once. I just thought it was super cool.
So it's very esoteric and very specific, but yeah, that's what I do in my day job. I read and write a lot.
So it's your fault.
Yeah.
Ultimately,
my fault.
All your fault.
Yeah. Yeah.
you are Oracle's friend, right?
Well, I'm whoever's friend I need to be at any given time, right? You know.
All right. Well,
who's on the right side of the equation? Yeah.
Let's go back because I don't understand a lot of it, and I'd love to find out, your path getting there. I understand you went to law school in Clemson, something like that.
Clemson was my undergrad.
2 undergrads, though.
Yeah, I got 2 undergrads. That's right.
Okay, poli-sci and computer sci?
Correct. Yeah, I got a Bachelor of Science in Computer Science and then a Bachelor of Science in Political Science. Correct. Then I went to Akron for law school with a heavy intellectual property concentration. And I've been doing the patent law thing ever since. One of the things that makes patent law a little bit different is you have to have a technical degree to do it. So you have to have that underlying technical degree to be a patent lawyer. And so there's not very many patent lawyers. And as a result, it's a more specialized field.
Yeah, I heard that's where all the money is. And my father-in-law, who's a lawyer, said that that's the big money.
There's some money in that field, yes.
And he was a lawyer working for the government. So he was an in-house government lawyer working on helicopter programs and things like that. So
sure.
He probably ran across you guys at one point or another himself. Now, one thing that kind of blew my mind is I was listening to you, I think it was with Nick Rekieta, and you had mentioned that you...
Oh, boy. Since this was 2020, this is way before the Nick Rekieta situation, so kind of a blast from the past there, that's for sure.
Took the patent bar before you even had graduated law school.
Yeah. So patent law is weird that way, and it's always been weird that way. It's one of those weird aspects of law. But yeah, to do patent law, you technically don't have to be a lawyer at all. You have to have the technical degree, but you actually don't have to have the law degree. It's one of those weird little things because it's so specialized, and there's not enough people to go around, not enough lawyers with the technical degree, at least in part. With just a technical degree, you can do it. So yeah, you can take this thing called the patent bar as long as you have a technical degree, and you can basically be a patent lawyer. Now in the U.S., they call them patent agents to avoid the confusion with people who have law degrees, but they are in practice the same thing.
Okay, so notice a couple things he said that stuck out to me is there are not a lot of patent attorneys in the United States, so it seems like there is a shortage of people with this expertise, and that's definitely what I'm running into personally. You have to have a technical degree, so it can't be like in the arts or anything like that. Like I was a communications major, so I couldn't be if I wanted to be, I couldn't be a patent attorney. So he does say like you are required to have some sort of technical, a college degree in undergrad in order to practice patent law. So it can be anything from like hard sciences, computer science, engineering, anything like that. So I thought that was pretty interesting. I did not know that. They also have a separate bar exam. So they take a different bar exam than other types of attorneys. And also he said you technically don't even have to go to law school. You could just, I guess, take the exam. Of course, most of them do go to law school. But I just found that super interesting that you don't have to, that they have, it's a very distinct area of law and so separate that they have a different bar exam. In fact, I was talking to an intellectual property attorney this week, who I'm excited because I'm supposed to interview him in the next upcoming week for a video here. But yeah, I thought it was interesting, and I didn't realize there was a lot of money in patent law. That's pretty cool too. So let's keep watching here.
That's very weird.
Yeah,
Very weird.
it's a little bit of a weird thing, but it's been that way since they invented it. Yeah, since the Venetians invented patent law in the 15th century. They were the first. So since the Venetians invented it in the 15th century, yeah, that's been the way it's been.
Okay, and that's great first question here, but technical degree as in
Some sort of hard science degree, so engineering, any engineering degree, chemistry, physics, computer science in my case, some sort
biology.
of what you'd call a hard science degree.
how about biology or
Biology, would that be fine? Sure. Yeah.
Okay.
So yeah, you have the biologists who do, you have biology, chemistry, and the mechanical engineers, mechanical people, electrical. So technically, computer science in this domain is considered a subset of the electrical arts. So those are the big fields, but you have to have some sort of what's called hard science degree. So you have to have, calculus and physics and those kinds of.
so gender studies
academic
wouldn't fall
subjects.
in the category.
What's that?
Gender studies wouldn't.
That would not be a thing that would qualify. No. Nuclear engineering, anything that ends in the word engineering will probably be fine.
Okay. Now, is that essentially every degree that would somehow be involved with creation of something or another?
Sure. So when you're thinking about what a patent fundamentally is going to, it's to what's called a useful art. That's the language the Constitution uses. So that's what we now call technology. It would be the more modern phrasing. So it's something, it has to be useful. It has to do something. It has to have utility. It has to be, for example, one of the differences between like a copyright and patent is like copyrights aren't useful. They don't do anything. So, like a movie, Harry Potter, or even the book, Harry Potter, it doesn't do anything. It's a book. It's a movie. It's words on a page. It doesn't do anything. It might have some meaning to you, but it doesn't do anything. As opposed to, widgets that do things. So, new chemicals, new manufacturing techniques, new gears, new widgets, new things that actually do some sort of, they change the world in some way by their existing.
Okay, and we're going to dig into it later when I talk about patent trolls about exactly.
Okay, so I'm excited because they do actually get into the topic of patent trolls, and I found that part really, I was like, that seems it's weird because this interview was like 4 years ago, and they're bringing up a topic that's kind of hot in our community right now. And another question I would have if I could talk to Kurt, I would really want to know how much of a working knowledge the patent examiner needs to have for patent applications they're reviewing. So if someone was reviewing a patent on sewing or embroidery, how much of a working knowledge, do they would they be required to have a working knowledge of those disciplines or, processes in order to understand the application? Like, how is that a requirement, or could someone approve and review a patent application for, say, a 3D applique embroidery process if they didn't know anything about embroidery? Is it possible that the patent examiner wouldn't really know much about that, or would they be required to have some working knowledge of whatever thing they're looking at? I don't know. So I thought that was pretty interesting. All right, let's keep going here.
What usefulness some of the patents that come across actually have. Good question in here, though. Does the technical degree dictate what patents you deal with?
It doesn't necessarily dictate, but it gives you, technically speaking, you can do anything in any field once you have the degree, but it would strongly correlate because you have the requisite technical knowledge to understand what you're looking at. So because my technology background is computer science, which is considered to be a subset of the electrical arts, so anything electrical engineering, I can do in a pinch. Anything computer related, it's fine. I could probably do a mechanical if I really had to, because I have some of the requisite degrees, but you put a chemistry thing in front of me and I'm going to die. I don't understand chemistry. I failed chemistry. I don't understand chemistry on any level. It hurts my mind. So chemistry and I did not get along. So When I look at a new piece of a new plastic, for example, I'm like, I have no idea what I'm reading.
Okay. Can we get into a breakdown of the different intellectual categories? Because honestly, I think I have a general idea, but obviously you can offer a lot more. Like, what is a copyright versus a service mark versus a
Sure.
patent versus fill in the blank?
Yeah, so the major three domains of intellectual property are patent law, trademark law, and copyright law. So patent law protects things that are useful, things that have utility, things that do stuff, things that provide some sort of real world use. So that's inventions, that's technology, that's patent law. Copyright is to artistic works. They're things that's, they're books, they're movies, they're songs, they're things that have artistic creativity, but no utility beyond that. So they're artistically interesting or inspiring, but they're not useful in the strictest sense. And then trademark deals with brand name, so it's brand recognition. So trademark extends to the name of something, and the primary purpose of it is to protect the consumer. So if you have whatever opinion you have of BMW, for example, or Apple might be a better example, because they sometimes are accused of having this halo around their name.
Okay, so that's really good information, and I see people confusing those things all the time. But he had a really good breakdown, very easy to understand, and that is that patents protect utility or things that are useful. Copyright is for artistic creativity type stuff like books, movies, paintings, that sort of thing. And then trademarks basically protect brand names, like name recognition, like Coca-Cola, like the Louis Vuitton logo, Nike, the name, the swoosh logo. So that's a really good distinction of the different areas of intellectual property. And yeah, I see a lot of people confusing those things a lot, but I think Kurt really explained them. That was a very good, simple breakdown. So what does everybody think about this video so far? I think it's super interesting. I'm fascinated by this kind of thing. So I do hope this is, helpful to you all, because I just thought it was really, especially with all of the conversations that were going in the comments of the patent legal threats video I put out. I just think I think this offers a lot of good background color that's helpful to us. All right, so we're gonna keep going here.
Their name. So because it is produced by Apple, if Apple comes out with a new product, people will buy it because it comes from Apple. That brand name has a reputation, and for better or worse, and whatever your personal opinion of Apple might be, maybe you hate them, but then at least you know that you're going to hate this new product because it was produced by Apple, right? So the whole point is to identify the source of the goods to the consumer, so they're not tricked. So if some guy opens the Apple shop, that might be unfair to the consumers because they think they're getting something that they're not.
Right, unless it's produce.
Yeah,
if it is in fact
produce.
And Apple themselves had to go through it because of Apple Records.
Yeah, sure. So and also trademarks tend to be in particular domains. So as long as they're in different categories, there's usually not a problem. So you can have a trademark in one domain but not another.
Right, but if I recall, Apple did ultimately cross swords with Apple Records because of the iPod, and they started to sell music, and they were seen as going into the Apple Records domain. Yeah,
which was part of their original settlement with Apple Music never to do that. So they were not only in violation of the trademark, they were in violation of their prior agreement with Apple Music.
I'm guessing though, it wasn't at the time, but when you're headed to become a $1 trillion plus company, you kind of were just pay.
They just gave them a big pile of money.
Yeah,
gave them a big pile of money.
Here, we'll give you a rounding errors amount. You'll be all right.
But I can give you a very famous case from trademark law that most people wouldn't know about to show you how these things can be interesting. So there's a fairly famous case of Burger King versus Burger King. So there's a guy in a shop somewhere, I think it's in Illinois, but I'd have to double check, and I think it's still there, who had the Burger King name first before the Burger King name you know and love. So this guy was opening a restaurant run called Burger King. Then the Burger King that you know about came about separately and got a national trademark. But because they had priority in their locality, they both couldn't compete against the other. So Burger King couldn't own any shops where the Burger King is, and Burger King couldn't open any shops where the Burger King was, because they both had priority over the other with respect to their domains. So it's a very famous case in trademark law.
Oh, that's awesome.
Yeah.
How about the Breyers Dryers?
Yeah. So yeah, the same kind of things where you get these fights among companies, fights among names, and confusion in the marketplace and what people do or do not understand in terms, and how sophisticated the consumer is, another aspect. So if you're selling to the general public or to an unsophisticated audience versus a very sophisticated audience that would know the difference, there's some different analysis there. But it's all down to it's all fundamentally down to consumer confusion. So if you go into, I don't know what a business that would not be competing with Apple computers off the top of my head, if there was
Anymore.
Apple window drapes, I don't know, but you probably would not confuse that with the Apple Computer Company.
Right.
So that might be okay.
Yeah, or the Apple farmers market.
Yeah, something like that. Yeah.
But yeah, it's getting rarer and rarer and rarer, and who knows? I mean, we can't even have Apple Automotive anymore.
Yeah, that was another example that came to mind, and I had to pass that over because I know they're getting into that space thing. So it's like, what is something that they're not doing that they're unlikely to do? I'm going to go with. I thought about clothing. I was like, no, wait a second, they sell merch, so that doesn't work. So I thought about watches. I'm like, no, they sell watches. What don't they sell? So I had to think of something.
My soul. No.
Yeah.
Give them time. Actually, that leads into a great long-term controversial issue, and that's Disney's seemingly forever copyright on Mickey Mouse. And
Yes.
Kevin Walker asks, why does Disney get to bribe Congress to extend their trademark protection for Mickey Mouse, etc.? 50 years is the limit, correct?
Yeah. So this is one of these things where you have to be careful in terms, because different things mean different things. So the thing there is copyright, not trademark.
Okay.
Trademark exists only for 10 years at a time, but it's infinitely renewable. So they only get it for 10 years at a time, but they can keep coming back and asking for it indefinitely. Copyright is life plus 70 these days, if memory serves correctly. And yeah, every time their copyright has come close to expiring for Steamboat Willie, which would be their first work with Mickey Mouse, they've always got an extension. The last one was the Sonny Bono Copyright Extension Act. And I think it is expiring this upcoming year, if memory isn't tricking me. So we'll see if they get another extension. But fundamentally, why can they bribe Congress? Well, that's a very
Called lobbyist.
charged way of putting it.
Sure.
Everyone has the right under the First Amendment to petition the government for redress of grievances. And so they would like to petition the government for their redress of grievances, namely that their copyright is about to expire, and they'd like it not to very much. So there you go.
Okay, so in your field, though, do you actually work with all of these, or are you pretty narrow on just the patent side of it?
No, I'm very, very narrow in my field. Not only patent, but specifically computer databases and search engines. So I'm pretty specialized in my field.
Okay.
So if I deal with stuff that's doing a search somewhere in the background.
Okay, so you can see here, Kurt, again, at the time he did this interview, he was a patent examiner with the United States Patent and Trademark Office, and his background was in computer science. So that was the type of patents he looked at. So I'm just wondering, just from my perspective, the people who are looking at patent applications for anything having to do with sewing or embroidery or like machines, I'm just wondering how much of a working knowledge of those areas they would have to in order to be able to know what they're looking at if they're reviewing those types of patents. So, all right, let's keep going here. But really, isn't this interesting stuff? Oh, and if you are kind of tuning in late, I normally will cover a few different topics during the show. So if you want to check out the Joanne's stuff, you can always kind of rewind the show. Like, this is sort of like a DVR. or you can catch the replay later. But normally I will. Often I'm not usually just talking about like one topic. The title, I usually will advertise like the main topic, but I will normally cover like a few different things, just so if you want to understand the format here. All right, let's keep watching here.
Whether that's on a cell phone or user device, whether it's the user putting in the search or it's automated, whether it's from a camera or a keyboard, but somewhere there's a search against a database. And that's typically what my field is. So it's very specialized.
Who ultimately owns a patent on a database, though?
Well, you're asking a little bit of an unfair question. I mean, no one owns a patent on the database, on databases as a general concept. They own it on particular manifestations of a database. So the one way to think about that might be to say, who owns a patent on car engines? I mean, that's ridiculous. But to say who owns a patent on a particular kind of car engine, well, we can ask that question because people come up with new engine designs, new valve designs, and all kinds of designs. And so there might be an answer to like who owns this particular engine because it's a new kind of engine. So in the same way, you say, well, who owns this database? I mean, the person who invented it, the person who came up with the new way of doing it. And sometimes it's very esoteric to solve a very particular problem.
Well, that's what I was going to say, because I do a little bit of it. And I mean, a lot of this is, there's going to be a ton of prior art out there going on back to the Unix community and prior. And I know Larry Ellison will tell you he owns everything probably.
Yeah.
But there's a lot of database stuff that was open source community created. And that's why I'm kind of like trying to get my head around it. I understand that there's maybe specificity in language and methodology that you could own that's not necessarily part of ANSI. And now I'm probably getting too deep into it, but is that what we're talking about? Is like methodologies of the way a functionality is performed by Oracle's, let's say, versus SQL Server in retrieval of data?
Yeah, and the retrieval of data, the memory management related to data, dealing with how different systems interop with each other, conversion of data from systems, redundancy of data, the failover orders, what is done on the server side, what's done on client side, orders of operations, search engine, and sort of big O notation kind of ideas about search engine optimization. But it can get very, very specific in terms of trying to solve a very particular problem.
Now that kind of starts to get down another path because, well, you're now in Texas, so you're in the same state as a particular breed of creature that is known as patent trolls.
Yes.
And one famous run-in involved podcasting. I started as a podcaster before doing YouTube stuff. And let's just say that they had from what I understand, a patent on something about episodic content being put into order.
Mm-hmm.
And sued Adam Carolla, Mark Maron, and everybody else for something that most people in technology would argue had been around well before any patent. I guess where I'm going, it's a long way about it, is how do you get a patent on an idea or a concept without actually generating anything? Just like, oh, wouldn't it be cool if we could do fill in the blank and then patent it, and then somebody else does the work to actually create something that does that, and they collide?
Well, strictly speaking, to get a patent, you have to teach someone how to build the thing that you invented. That's part of the disclosure requirement, that you have to teach someone how to build it, to give them enough information on how to create it for themselves. That's part of the whole deal. It's like, we're going to give you a monopoly in exchange for the information, for the new discovery on how to do it. If you don't want to tell us about it, you have trade secret, and that's a whole different side of the problems. But yeah, so if the patent isn't providing you a way of doing it, if it doesn't teach you how to do it, then it's an invalid patent. If there's prior art on the specific disclosure, it would be an invalid patent. But to figure out whether or not it's truly an invalid patent, you have to actually get into the weeds of the thing. You actually have to go and read the claims, and you have to go read in each and every word, and then you have to go and interpret them in light of the particular specification. And it requires a lot of nuance and a lot of detail. It can be very, very pedantic at times. And so it requires a lot of attention to detail.
All right, so you see here, this is interesting. He's saying that, one, you can, in order to patent something, you have to show someone like how to do this thing. And even though a particular concept may not be able to be patented, if you can come up with a new or very specific way to do it, you may be able to get a patent for it. He's also saying that to invalidate a patent, it seems like it's pretty complicated. And again, he's saying it requires you getting into the weeds. And, you know, I know a lot of folks have been saying, well, this isn't a new idea. This has been done before. It's called trapunto. I think it's a bit speculative to say that without having the analysis of someone with expertise like Kurt has to really examine the patent and determine that. So I just don't think it's so easy to be like, well, needs to be I don't know. Like, that's the thing. And unless you are a patent attorney or a patent expert, the reason I wanted to show you this is to demonstrate that this is just an area of the law that most of us are really not familiar enough to be able to make definitive statements about it. So that's why I'm really refraining from saying, like, this is BS or, like, this is crazy. Again, it does seem crazy, but, you know, we can't really say for sure. So we can't really say for sure. So I don't think it's that easy, guys. I don't really think it's that easy.
And it's expensive too, right? I mean, you have
It
to
can be
have
very
the
expensive,
researchers who know what they're doing. You have to track down all of that, read it. And isn't the basic theme of the patent troll to hit a company for saying, oh, just give us $20,000, $40,000 and we'll go away, or 100,000, whoever it is, like Apple.
Yes. Well, first of all, patent troll is the politically incorrect term. These days we call them non-practicing entities. So
Okay.
we're much
like
politer about it.
non-practicing
But yeah, that is a
That's so long.
classic
Because-
arguable business model of some of these companies who some people might believe are engaging in those kinds of practices.
Okay, well, but patent troll rolls off the tongue better.
Yes. We had to come up with a different phrase for it, though. So, no,
I like that. They're not patent trolls. They're non-practicing entities. That's kind of hilarious. Oh boy.
practicing entity.
Well, I mean, what are your thoughts about your description?
Well, it depends very much on the specific patent. I one of the things that I have trouble with, and I have trouble figuring out how to communicate this particular subject to people who are not professionals in the field, which is one of the reasons I don't talk about it on my channel, because I feel like it requires so much detail. It's very hard to do in an easy way. But it requires a lot of attention to detail. And some things that look bogus on first blush are not really bogus once you get into the details of the thing.
See, this is what I'm saying. Like, he even said a lot of things you think are bogus might not be bogus if you really get into things. So, you know, that's where I'm like, yeah, I don't know, you know? Yeah, exactly. It would take a company with deep pockets to dispute the patent that we all discussed. Yeah, I think that's probably a safe bet to say. And it would require getting someone with the expertise the expertise necessary to be able to say, to give an opinion on it. And then it would take a lot of money to try to fight it. I know on surface level, everyone's like, this is ridiculous. You know, it might be legit. I don't know. Might be legit, might not be. It's rough. It's rough, guys.
So some of the things that are sometimes paraded out as junk patents are not really junk, or at least they don't seem to be to my eye once you get into the details. Now, that isn't to say that someone couldn't agree with me, but it feels like a lot of the discussion online is somewhat blunt and not necessarily particularly down into the weeds of the thing. It's like man passes patent search engine on computer. I'm like, no, that's not exactly what's going on here, and I don't even know where to start.
Okay, well, and I think that's completely fair because sometimes things may appear to be minor and they're actually complex. Like a lot of people getting annoyed with Apple
Sure.
and saying it's perfectly obvious for the click wheel to navigate a list. And that was absolutely original because I've been in technology long enough to say, no, hell no. Nobody had ever thought of that I know of. It was very novel and it was functional. Same way as, well, it's obvious to just put a keyboard on a screen and to use only the whole screen for an iPhone. It's like, well, no, it really wasn't. That's why everybody had a keyboard on their device for every device before that. And if you want even more proof, look at the original prototype for Android and you'll see that it looked like a BlackBerry and had a keyboard physically on it.
Yeah.
What I'm referring
That's
to,
another thing too. Like everything is obvious in retrospect, and people don't respect the dates. So they'll see some patent that was
Sure.
issued in, they'll see something issued in like 2003, and be like, "Oh, that's so obvious." I'm like, "But was it obvious in 2003?"
Right.
And he's like, "Of course it was." I'm like, "I'm not so sure. Maybe we actually have to go look."
Yeah, definitely. I mean, it's kind of like that Radio Shack ad that they famously had that the entire front page is now on an iPhone.
Yeah, exactly, right.
On that note, though, and gotta Biden the cold one. Hello again, Mr. Hunley. Caught your show and Nick Rakita. Hi, Kurt. Hope you're well. Keep up the good work. Thank you, sir, and thank you for the super chat.
By the way, I really love all of the Nick Rekieta references. This is in 2020, just in light of everything that's happened. It's just sort of comical to see everyone referencing seeing the Nick Rekieta show, just because, yeah, a lot's happened since 2020.
I want to be very specific, though, and to hopefully narrow it down. I'm talking about a particular group who seem to be in East Texas. I don't remember the exact, but very, very limited jurisdiction. They seem to always sue to bring corporations to Texas, and their entire industry seems to be a series of PO boxes and non-business addresses explicitly for the purpose of what I would say is exploitation of the patent system.
Yeah, so that's the famous town of Marshall, Texas, where a lot of these things were filed in the Eastern District of Texas. A lot of these things, to the point where Samsung, somewhat famously, had an ice rink outdoors in Marshall, Texas, in order to have an ice rink, so people would see the Samsung name. They wanted to keep that up and running in the heat of
We're gonna fast forward a
Texas,
little bit. Let's see.
trying to get around that to varying degrees of success. But
Okay.
case a couple years ago, where Supreme Court said you got to stop doing this. You can't just sue them wherever you like. You have to sue them in their principal place of business or where they're incorporated. So they took a lot of that away. And some people have been trying to get around that to varying degrees of success, but the Supreme Court took a big bite at it. But yeah, the juries in Marshall, Texas were known for finding infringement all the time. They always found infringement. So it was somewhere you always wanted to sue if you're in the infringing category, because they always seem to, for some reason, rule for the infringement. So yeah, that was a thing.
It was almost like George W. Bush never met a bill he didn't sign.
Yeah.
And I will say, I would be super curious if I can get a chance to talk to Kurt. I really would want to know his take on whether patent protection would extend to digital content like YouTube videos. I'm really curious to see what he would have to say about that, to see whether that would be a thing or if that's totally ridiculous. I don't know.
Okay, well, and I'm glad to hear that they did that, because I'm mixing up a lot of things because obviously I'm a novice, but I didn't know if a way to deal with patent abuse, I would say, would be something like, and I know it's defamation, but slap. Is there a way to put something in, like, let's say, where if you put forth and chase somebody about your patent, but it can be proven that there's prior art or whatever, that you can be saddled with legal fees? Would that be a potential way to maybe help mitigate abuses in the system?
I suppose possibly, but to do that, you're going to have to get. I mean, SLAP exists as a matter of state law. They were passed by various state legislatures, and patent law is exclusively federal. So you need to get the United States Congress to pass some sort of version for that for patent law.
See, I did not know that. So patent law would only be federal courts and not state courts. So that's also interesting. So if someone was to sue you for patent infringement, it would have to be in federal court and not a local court from what he's saying. I don't know.
But yeah, you could do that.
Do you think that would be effective?
I think it'd be unlikely to get it done. Actually, getting it through Congress is a whole nother set of problems. But yeah, if you could petition Congress to come up with some sort of some sort of slap for patent law and get that through. So let me know how that works out for you, I guess.
Yeah, I'll be right on it. I'll hire you to put it through.
Yeah, that's good.
All right, before we get
You're
started,
gonna need a big pile of money and a lot of time.
Oh, okay. I'll write you a check. Before we got started, you were talking about in patent law that a lot of times people overlook another kind of patent. We're very concerned, obviously, with the design patent and rounded corners and things of that sort. But plants are another kind of patent.
Yeah, so patents come in three principal varieties. The utility patent is the one that I talk about the most because that's the most dominant kind by far, which is for a useful article. Then you have design patents, which are for design elements in a useful article. So the famous patent with Apple with the rounded corners of their icons that people get so snippy about, that's not a utility patent, that's a design patent. And as a result of that, I mean, it's a perfectly valid patent. It's a design element in a useful article. The iPhone's a useful article. It does useful things. And so it's a design element and it protects the unique design. To not infringe, it's easy. Just don't have rounded corners. It's not that big a deal.
Well, that came out of the
type of patent for certain types of plants, like the things that grow from the ground, for if you want to come up with a new kind of patent. So if you're a Monsanto, or you're a farmer somewhere, or you're a apple grower, or the state of Washington in one case, which got a patent for a new breed of apple, then that's where you go to the plants.
Well, and that's because technically plants are being genetically modified. Even if you're splicing together, you're adding things together almost like chemistry to create something else.
Yeah. I mean, you're always looking for the next thing, and there's it's challenging.
Okay, now you had mentioned the rounded corners. Now that was all tied in with the Apple v. Samsung lawsuit, right?
Yeah.
And on that one, in fairness, I think by any objectable measure, people could look at the Samsung and look at the Apple and say, one of these is very much like the other.
Yeah. I mean, with the rounded corner thing, I mean, they look the same. The nice thing about design patents, the real controversy was on the amount of damages, because the way that the statute was written was a little bit vague how the apportionment of damages should be calculated. But the actual underlying infringement was fairly easy. I mean, this is rounded corners. This is rounded corners.
All right, guys, I want you to keep in mind that Kurt, the guy on the right from Uncivil Law, he worked at the United States Patent and Trademark Office for 14 years. So this is someone that knows what they're talking about. They're a patent attorney, and they worked as a patent examiner for 14 years at the USPTO. So his insight is worth listening to.
Right, and the consumers were being confused deliberately because Apple was only being sold with AT&T stores, whereas Samsungs were flooding out the other cell phone carriers, and people were going to start be like, "Oh yeah, it's practically an iPhone, sure."
Yeah, well, I mean, when you're taking advantage of someone else's inventions, discoveries, goodwill, their branding, their the way things are designed. When you're making things look a certain way, it's not really fair competition now, is it? Come up with your own thing. Make it better than the other guy's thing. Why are you copying their thing? They came up with it first. It's theirs. So yeah, it's basically just unfair competition at its root.
Now, out of curiosity, though, have you noticed around? And if you haven't figured it out, I'm a huge Apple fanboy. So, but I go around and I look at like BJ's or Costco or whatever, and I see headphones that are in a case that looks just like this, and the headphones. There's a big picture of them, and they look, I mean, identical to this, and they're being sold, mainstream. It's like, hey, that's $30, that's $40, and they're so obviously blatantly clones. Is that Apple just saying, I really don't care?
It could be a whole lot of things. It could be Apple saying, I just don't care. It can also get very, very sticky, because if you are, it gets into weird boundaries between patent law and to the useful article, because Apple, their patents, to the extent they exist, and what's actually going on there, and the boundaries of trade dress, and what is and what is not fair competition. And Apple, if they can be bothered, and maybe it's good marketing for them on some level because it means their product's more popular. I couldn't begin to know what's going through Apple's head. But if Apple wants to give me a big pile of money, I think I can help them with many of these infringers. Some of them may be judgment proof. It may not be worth their time. So there's a lot of potential reasons, but I'm available if they want to give me a big pile of money.
Okay, well, I'm going to start to move off of the whole patent thing. Before I do, though, what am I missing? What did I leave on the table that I really should have asked you?
I think you really got the principal things. It's just trying to keep the boundaries between concepts is probably the hardest thing, because people use the terms a little interchangeably because they're not used to hearing the terms. And so trying to make sure that you're using terms properly. So, patents protect things that are useful, that do something. Copyright protects artistic work, and trademark protects names and source identifiers to say what is the source of this product. So just trying to keep those concepts separate, and they have different kinds of lengths of time, different coverages of things, and it can get complicated. But I think a lot of people see just the article with the headline, and they kind of reach wrong conclusions because they're kind of looking at things very broadly, when sometimes it's the devil's in the details, which is, I guess, true in many fields of law, to be quite fair.
Yeah, it makes sense. And actually, no, I'm going to reach back in for one more thing, because you mentioned it's a whole nother mess. Trade secrets.
Sure. So the most famous example there is the recipe for Coca-Cola. I mean, that's the most famous trade secret of all.
All right.
So
I think that's about it for this, but this was fascinating, and I'm really glad we got to take a look at this. What did y'all think? Did you learn something from this? I definitely learned something when I watched it, so that's why I wanted to share it with you, because I just saw a lot of things being thrown around in the comment section of that patent clip I put up, and I just thought this would be super helpful, especially if you didn't previously have a lot of knowledge about how patents work or how the USPTO operates. I thought this was super helpful. So thank you very much to Eric Hunley and Uncivil Law Kurt. If you haven't checked out their channels, they do have a lot of very interesting law topics. In fact, I had no idea that Kurt was a patent attorney, because I don't think I've, other than this and maybe like one other thing I was able to find, I hadn't really seen him ever talk about patents or IP or anything. So he normally covers like crime and Supreme Court type stuff on his channel. So I had no idea this was his area of expertise. And he did mention that the reason he doesn't really talk about it a lot is because he can just easily get so into the weeds, and it requires so much detail. So I totally understand that. So thank you very much to Eric Hunley and Kurt from Uncivil Law for letting us react to that video. But if you want to watch the whole thing, it is linked in the description box of this video. But again, that's why I think this patent situation is more complicated than it might look on the surface, and it would require us to get a breakdown from someone like Kurt. Again, I did try to make contact, so we'll see what happens. I can't promise anything, I am really excited though because coming up this week, I'm supposed to be interviewing an intellectual property attorney with a lot of experience in e-commerce and social media. So we're going to be having a conversation that I think will be very helpful to us makers, especially if you sell things, you make, or if you are like a social media influencer, or even if you're just a business that uses social media. I think it will be really helpful for you. So I'm pretty excited about this conversation with another IP attorney. And I will and when I was I did ask him a little bit about this patent situation. He's like, I can't even, he's like, that's totally not in my wheelhouse. I can't even, he's like, I wouldn't even have anything to say because it's just not my area. So that's, and that's what I'm talking about. Like me reaching out to like Legal Eagle or Emily D. Baker would just not be helpful. Plus it would be cringe because they're such massive channels and they wouldn't get back to me. So I just wanted to share that. But I thought that that conversation about the patents was really interesting, especially since they did talk about patent trolls, because that's, what we are alleging. That's what we're alleging